Hello, I'm attorney Brian Williams, and I'm going to explain some things about Chapter 7 bankruptcy. Hopefully, this clarifies the process and answers some questions that you may have. Bankruptcy laws deal with situations where debtors are unable to pay their debts. Pre-independence bankruptcy law was based on English common law and was harsh. The law confiscated debtors' property and gave it to creditors, and the debtor could be imprisoned. Cases were involuntary, meaning that creditors filed the case, and these laws were not tools to help debtors. Incarceration for failure to pay debts was a thing. After the U.S. Constitution was signed, Congress enacted bankruptcy laws that developed into the system that we use today. The laws attempt to be fair to both creditors and the debtor. There's no incarceration or criminal penalties for not being able to pay debts, and bankruptcy can be a positive tool that helps people. There are different chapters of bankruptcy, and today we'll talk about Chapter 7 bankruptcy for individuals. Chapter 7 bankruptcy is a liquidation case. This means that any non-exempt assets that the debtor owns are sold, and the proceeds are used to pay the creditors. This part is similar to the old English common law bankruptcy with one huge difference. The laws now allow for the debtor to claim exemptions that exclude certain property from being a part of the bankruptcy estate. There are federal exemptions in the bankruptcy code, but some states have their own exemption statutes that are used in bankruptcy. I practice in Maryland and Washington, D.C. Maryland requires the debtor to claim the Maryland exemptions, but D.C. allows the debtor to choose between the federal exemptions or the D.C. exemptions. The analysis of the debtor's assets and available exemptions is extremely important in deciding whether to file a Chapter 7 bankruptcy. If the debtor has assets that are not exempt, oftentimes a Chapter 7 bankruptcy is not a viable solution. It's essential to obtain accurate valuations for real estate or any asset that has significant value. This pre-filing analysis will determine if a Chapter 7 will be the debtor's best option. The biggest negative in filing a Chapter 7 case is the potential liquidation of assets. The debtor needs to know before filing if they're at risk of losing anything. A bankruptcy case is started by filing a set of forms with the bankruptcy court that disclose the debtor's financial situation. Creditors can still file involuntary petitions for debtors, but today we're going to focus on voluntary petitions filed by debtors. The assets, income, expenses, and debts are all disclosed on these forms. When a bankruptcy case is filed, an estate is created that includes all of the debtor's assets. The debtor must include everything that they own or have an ownership interest in. Debtors' assets are a part of the bankruptcy estate even if they're not disclosed on the forms. One of the most common questions I get about filing a bankruptcy is, do I have to list this asset or this debt? Or potential clients that say, I want to file without including an asset, or I want to keep this credit card. Everything must be disclosed. The court appoints a trustee to administer the bankruptcy case. The trustee will determine if there are any assets that would be available to sell that would bring money to creditors. There's one hearing scheduled about a month after the case is filed. The hearing is called the Section 341 Meeting of Creditors. Although it's called the Meeting of Creditors, it's not common for creditors to appear. In practice, any issues that creditors have are usually handled by filing motions in bankruptcy court. It's typically just the debtor and the trustee at the hearing. The trustee examines the case to determine if there are any assets or income that will be available to creditors. The trustee will review the valuation and income documents that the debtor provides, but will also perform an investigation into the debtor's assets on their own. The debtor is required to swear, under penalties of perjury, that all of their assets and income are included in the case. The court will prosecute debtors for dishonesty, but will also dismiss the case without discharge or revoke the discharge for dishonesty. The next analysis in the Chapter 7 bankruptcy is to determine the debtor's ability to pay creditors. One of the forms that must be filed in a bankruptcy case is called the means test. This form compares the income that the debtor has received in the 6 months prior to filing the bankruptcy to the median income for a household of the same size. It's designed to exclude people from filing Chapter 7 that have the ability to pay something to their creditors over time. The Department of Justice publishes a chart listing the median income that is updated several times every year. If the debtor's income is higher than the median income, there is a presumption that their case is an abuse of the bankruptcy laws. This presumes that the debtor will have some income available to pay creditors. It does not mean that the debtor cannot file a Chapter 7. An over median income debtor may have expenses that take up their income such that there is nothing available to pay creditors. The means test contains allowances for expenses, but in some cases the debtor's actual expenses are higher. I would need to perform detailed calculations to determine if an over median income debtor would be able to file a Chapter 7 case. If the debtor fails the means test, the trustee will file a motion to dismiss the Chapter 7 bankruptcy or to convert it to a Chapter 13 bankruptcy. The Chapter 13 would require the debtor to pay what their budget allows into a repayment plan for 5 years. In addition to the means test determining the debtor's potential ability to pay, the debtor is required to file a current budget. The means test is based on the 6 months prior to filing, but the debtor must also file a forward-looking budget. If this budget shows the debtor has an ability to pay creditors, they may be forced to convert to a Chapter 13 or to have their case dismissed. The analysis of the debtor's income and budget is also very important. The debtor should know before filing a case if they may lose assets or if they may not be eligible for a Chapter 7 bankruptcy. A person should consider bankruptcy if they are overwhelmed by debt and do not feel that they can pay it. I can analyze the situation to determine if a bankruptcy is their best option, be it Chapter 7 or Chapter 13. Oftentimes, creditors force debtors into filing bankruptcy by aggressively collecting debts. It may be harassing phone calls, filing lawsuits, garnishing bank accounts or wages, repossessing cars, or foreclosures that puts debtors into bankruptcy. One of the benefits of filing a Chapter 7 bankruptcy is the automatic stay of Section 362. As soon as the bankruptcy case is filed, the automatic stay stops collection against the debtor. Creditors must stop calling the debtor, and lawsuits, garnishments, repossessions, and foreclosures are all stopped. In some cases, cars that have been repossessed must be returned to the debtor, and funds that have been garnished that exceed $600 must be returned to the debtor. The automatic stay is a very helpful tool when a debtor is faced with aggressive creditors. One potential negative factor in filing a Chapter 7 is the liquidation of assets. If the debtor does not have non-exempt assets, that's no longer a concern. Another negative factor in filing a Chapter 7 bankruptcy is the negative impact that it has on the debtor's credit. The bankruptcy will appear on the debtor's credit report for 7 to 10 years, and in most cases, it reduces the debtor's credit score. It may make it more difficult to get apartments, and car loans may have higher interest rates, and credit cards as well. In most cases, the debtor must wait 2 years before getting a mortgage loan. Banks do, however, seek out people who have recently filed bankruptcy and will send pre-approved credit card applications and offers to buy cars shortly after a case is filed. After a successful bankruptcy, the debtor does not have many other debts to pay. This is one way that a debtor can rebuild credit after filing bankruptcy. If a person has debts that they are struggling with and cannot reasonably expect to pay them within 5 years, they should consider filing a bankruptcy. A debtor can have good credit fairly quickly after filing a Chapter 7 case, even with the bankruptcy on their credit report. In some situations, a person can have better credit by filing the bankruptcy because it relieves them of some of the burdensome debt and allows them to start over with debt that they can afford and manage properly. The bankruptcy provides a fresh start for the debtor, and as long as they take steps to rebuild their credit, they can have good credit score in a year or two after filing bankruptcy. Discharge is the goal of filing a Chapter 7 bankruptcy. The discharge is a court order that makes the debtor no longer legally liable for debts. It does not list the debts or any specific amount. Certain tax debt, child support, alimony, government fines like traffic and parking tickets, and most student loans are not dischargeable by law. Other debts may require litigation to determine dischargeability. Some tax debt is dischargeable, and that requires a detailed analysis of the debtor's tax situation. For someone who is overwhelmed by debt, a Chapter 7 can be an extremely helpful tool to start over. If you have questions regarding bankruptcy or would like to get started, call me at 301-891-8485 or visit my website at www.brianwilliamslaw.com. Thank you.